Now we're on to our next panel, which is criminal and dependency crossover issues in your family law domestic violence case. Our panelist includes Commissioner Cohen, Laura Cohen, and Commissioner Cohen presides over restraining order matters downtown in Stanley Moss Courthouse. Prior to that, she was a clinical professor at Southwestern University of Law, where she's credited with creating and implementing a program called Street Law Clinic that was taught by law students, and they taught law-related critical skills to foster children and children on probation. We also have Dmitry Gorin, who's a partner at Eisner Gorin. It's a boutique firm in Los Angeles that specializes in criminal matters. Dmitry is a certified criminal law specialist and a former district attorney, and he specializes in complex criminal matters on both the state and federal level. Next, we have Mark Tseselsky, and Mark has his own boutique firm and specializes in family law and juvenile matters. He was previously with the firm Vincent Davis, where he also practiced with family and dependency. He's very involved in the local community and is a great asset in our family law cases as well. And with that, I'll let you guys get started.
Thank you. Thank you very much to Aaron and Chelsea for inviting us to present today and for putting this amazing symposium together. I really learned a lot this morning already. During a divorce proceeding, husband accuses the wife of child abuse. LAPD is investigating her for slapping the children, leaving red marks, but no bruising. Children are 8 and 12 years old, and also investigating her for being verbally abusive. Penal Code Section 273A. DCFS is called by LAPD, has opened a child welfare investigation to determine whether to detain the minors from one or both of the parents. DCFS seeks statements from both parents, from the children, and wants any and all recordings, texts, emails, and evidence to help make a decision. So we're going to relate this to our panel number 1 here. The 12-year-old surreptitiously recorded the mother when she was using verbally abusive language with her and her brother. The husband is considering filing a DV restraining order in family court, as the wife has also been abusive towards him and threatened to take the children back to Thailand to her family. Both parents have previously dealt with alcohol abuse issues and have a history of both being verbally abusive and combative with each other. So since it starts primarily in the criminal realm, we thought Dmitry would start to talk through what would happen in this scenario.
Sure. Good morning, everyone who's attending, and thank you, panelists, for participating and preparing with me here. Yes, this fact pattern is actually very real. I'm sure many of us who have practiced family law and other areas, this is something we hear about all the time. So this isn't just a made-up fact pattern. This happens. As a criminal defense lawyer and a certified specialist, I get calls frequently when the police are involved in investigating. Most of my clients are professionals, people with no records, doctors, lawyers, entertainers, etc. And they don't want a criminal record. They don't want to be arrested. And furthermore, more importantly, in this case, they don't want their kids to be taken to another country and not see them. And so from a criminal law perspective, I got to make sure that my client is not arrested. And my goal is to get the case closed and not have a single criminal charge on their record. And so in a situation like this, whenever there are these accusations going back to an acrimonious divorce, often the person that's first in the door to the police gets some action from law enforcement and the other spouse gets a call. I usually will contact Mark Tseselsky when DCFS is involved, because in my world in criminal, I do not let my clients talk. If I do want to have a statement made, I put that in my own words, I put it in a letter. But from the DCFS perspective, if the client doesn't talk, that's held against them and they could lose their kids. So there's this balancing situation of, do you let your kids talk or not talk? I'm sorry, do you let your client, the mother or the father, make statements about what happened or not? Just generally looking at this hypothetical, and I encourage you guys all to take a look at it in the materials because the facts are important. It's almost like a law school question with a lot of facts here and a lot of issues. The first thing that's going to happen is to your client is they're going to get a visit from LAPD. And in this case, the mother is being accused of hitting the kids. And you know, obviously, in this day and age, that could be considered illegal. On the other hand, there is a penal code provision, it's a defense that you also have in your materials about parental discipline, and parents have the right to reasonably discipline kids. So the law actually provides for parents to be able to use some amount of physical force. Doesn't mean it's good parenting, but in fact, the jury instructions would provide for some amount of force, corporal punishment of on children. That's not between spouses. One spouse can't discipline the other. That doesn't apply to that. So I'm kind of talking tongue in cheek here, but as to kids, just the fact that even if there is a slapping, that's not per se criminal, according to the law. And furthermore, in this fact pattern, the kids aren't injured. I've seen plenty of cases, both I was a prosecutor for 12 years and I've been a defense lawyer for many, many years. There are some really bad child abuse cases out there. But if all we have in this fact pattern is the kids have some redness, that doesn't mean there's a crime committed. So there could be a reasonable use of parental discipline under the law. And oftentimes when LAPD will respond, so just imagine one of your clients calls LAPD or the sheriffs, whoever's the local agency, they come out. As soon as there's a claim of possible child abuse, DCFS will take action. They're under a lot of scrutiny lately for not taking action in situations where kids die. So sometimes now they overshoot and end up being more aggressive than they really should. So now not only is the client worried about having an arrest, having something on the record, not being able to work because of conviction down the road, they're worried their kids are going to be taken away. And that's when I call Mark to deal with the situation. And I'm going to turn to Mark in just a second. I just want to unpack some more of these issues here. Oftentimes in my cases, I get calls from family law practitioners on the issue of one spouse recorded the other spouse. Is it legal? Can I use it? And in fact, the penal code does provide for surreptitious recording in a situation of violence and domestic violence and related crimes. So that in this fact pattern, the 12-year-old recording their mother using abusive language, that could very well be admissible evidence. Now, abusive language again, and I pulled the relevant statute in in the materials you have, really doesn't amount to threats. I mean, criminal threats are prosecutable, but abusive language, bad parenting, that's not necessarily criminal. That may have impact in your custody, and I'll turn to Judge Cohen for that in a second. But abusive language is not necessarily criminal. In fact, the statutes in criminal law, I've done a lot of trials dealing with people talking and then somebody smacking them. There's a jury instruction specifically saying that no words can justify the use of unlawful force. So even a battery cannot be justified based on words alone. And that's the jury instruction. So that's an important thing to remember, but that doesn't mean that any abusive language is in fact criminal. So that's another important thing to consider. And then another thing to consider here, you know, as I was referring, there's a section in the penal code about child abduction. And I've had a number of international child abduction cases where one of the parents is not doing so well in family law, perhaps runs out of money, or grandparents feel one of the parents, not their child, but the mom or the dad is being abusive to the kids, and they just take off with the kids to Finland, to Indonesia, to other parts of the world. And so this is a reality. This does happen. I've had a number of child abduction cases. And then what happens is eventually the parents or the grandparents are arrested 20 years later, and the kids never had contact with the other parent. So the kids have grown up without the other parent in their life, and now want really nothing to do with their mother or father who they've never seen. Now, there may in fact have been issues of abuse, but in fact, it's not a defense under California law to say, well, I believe the kids, may be abused by the other parent, I'm just going to take them. There's actually a process in place in the jury, and the jury instructions refer to that. On if one of the parents takes the kids because of abuse, you have to notify the local DA's office. There's steps you have to take. And so that is a pretty significant issue in criminal law where kids are abducted by one of the parents. And finally, in this fact pattern, there's issues of alcohol abuse, verbal abuse between the spouses, and it's just a sign of, dysfunctional relationship that I quite often see in the criminal world. A lot of my clients, again, are very successful professionally, but then when it comes to their personal situation in their life, they may not be the best parents and not the best spouses. So those are the criminal issues I see. I'm going to turn this over perhaps to Mark Tseselsky now to deal on the DCFS situation, and then the court, Your Honor, to deal with the domestic violence restraining order, and also how do you address this concern about the child abduction issue? So Mark, please.
Good morning, everyone. So Dmitry is correct. This fact pattern has the full bouquet. The only thing it's missing is accusation of sexual abuse, and that would make it the full house kind of version of a fact pattern. When DCFS looks at a situation like is presented in this fact pattern, what they're going to be considering is safety of the child, obviously. If they feel like one of the parent is able to take care of things without the social workers needing to get involved, then there's a good chance that the social workers will not necessarily get involved, even though it looks like their involvement is necessary. So we're talking about criminal, we're talking about family law. Let's start with criminal. Let's say the fact pattern is a little bit different, and one parent is already, incarcerated in jail. They're awaiting their trial, and the child is with the other parent. Well, then they're a lot less likely to get involved in that case, even though by all means, this should be something that should be a case for them. Similarly, if there's a family law case going on at the same time and somebody run to family law court and got the ex parte granted, and now one parent has custody and the other parent has monitored visitation, that's also going to affect the calculation for the DCFS. Somebody in the question and answer queue asked where the materials are. I see that the total materials provided are like 171 pages. I looked it over. Our materials start at page 51. And the next thing that I want to talk about is on page 88. And this is what this is called SDM risk assessment. This is literally what the social workers look at when they make a decision whether or not to promote a case to a court case. How do DCFS get their cases? Well, this hypo presents one such situation. Law enforcement is involved. Another situation is someone who is like Commissioner Cohen, who just had enough and there's just too many issues, and Commissioner Cohen can refer a case to DCFS. Minus counsel can refer a case to DCFS. Usually what happens, it's a school official. A kid says something to another kid. That kid tells their parents, little Johnny said blah, blah, blah. And then the parent of the other kid goes to a school official, and then it unravels. A therapist is a mandatory reporter. And whenever they hear anything concerning, they have to report it to DCFS, and then that gets the ball rolling as well. So when the social workers get this referral, they have the option of evaluating it out. This is what I was talking about earlier. They can look at, oh, look, there's a criminal case already, we don't need to get involved. There's a family law case already, we don't need to get involved. Or it doesn't seem like it's serious enough for them, they can just say, offer some materials to them and whatnot. But ultimately, if they do decide to investigate, as they should, as they're required to do, the potential outcomes, there are 3 potential outcomes. And we can start by looking at that on page, let's see what page is that. That is talking about the 3 different kinds of, this is Penal Code section 11165.12, and it provides 3 definitions of possible outcomes. One is the allegations are unfounded, meaning that they just close the allegations and it's over and done with. There's nothing there. Then there is the substantiated, meaning that they found enough there and now they have a decision to make whether to promote the case into a full-blown court case. And then there's inconclusive, which is something in the middle, which basically means there's something there, but it's not enough for us to open up a court case. So when they make those kinds of decisions, whether to go ahead and open up a court case, they're going to look at this thing called SDM risk assessment. It's strategic decision-making risk assessment. It's an attempt to quantify the risk, because in order for them to get involved, nothing actually needs to happen to the child. So like Dmitry mentioned in a hypothetical, there were red marks. Okay, so it was not necessarily the case that the child actually got hurt. It doesn't matter, because under Welfare Institution Code section 300, if there is a substantial risk of harm, then they will get involved. And it doesn't take much sometimes for them to get involved. Sometimes I basically tell the clients, look, you have to know how to communicate to them, or you're going to be in contempt of the social worker. You're going to piss them off, and they're going to open up a court case just because you pissed them off. It happens. They're human. They're overworked, underappreciated, and they have a very stressful job to do. With that risk assessment, they look at if there's prior history. So if this isn't the first phone call, which in a hypothetical, there was discussions about they have history of domestic violence and substance abuse. That sounds like that could be the case, because if police were called before, that in their mind increases the chances that something will happen. It increases the substantial risk of harm. So the first, if you look on page 88, the first 3 paragraphs are just questions asking were there prior referrals regarding neglect, regarding abuse? Is there an ongoing open Child Protective Services investigation? And of course, to round out that discussion, if actually something really did happen, a physical injury did happen to a child, that just escalates it to another level, and they are a lot more likely to get involved. And then paragraph 5 is just trying to identify what kind of case this is. Is it neglect? Is it physical or emotional abuse? Is it something else? The number of children involved in paragraph 6. So if there are more children, more problems, meaning that if you're handling a household with 4 or more kids, there's just more risk in their mind, so that it makes it more likely they get involved. This next one, paragraph 7, is my favorite because it's so subtle, and you really need to pay attention and explain to the clients what that is about. Because primary caregiver assessment of the incident, caregiver does not blame the child, caregiver blames the child. It is very easy to fall into temptation of appearing like you're blaming the child. If the mother is being interviewed and about leaving those red marks on the children. And she starts talking about, well, you wouldn't believe what little Johnny was doing at the time. It sounds like the parent is blaming the child. And in the mind of the social worker, that means we need to get involved, because the parent doesn't get that they're the parent. They're supposed to have it together. They're supposed to be able to contain it when the kid goes buck wild, instead of start hitting them. So I spend a lot of time on this paragraph when I go over this with clients in preparing them for the social workers interview, because it is not something that most people would think of. Most people would think sharing anecdotally about what little Johnny did is perfectly fine with the social worker, and it's not. You really want to stress how, yes, little Johnny was misbehaving, but I was wrong to use so much force. You should portray to the social worker that you're open to learning from this experience instead of trying to be defensive, because what happens in a lot of cases is people get very defensive because here is the government coming in and telling them how to parent, and then they start this back and forth with the social worker, and next thing you know, the social worker wants to get involved just to show them how wrong they are about how they do things. If the parent takes the approach of, well, maybe I could have done this differently, then it increases the chances that the social worker will end up closing this with just a warning and here's some resources. And if you do the resources, then you're going to be fine. So the rest of the items on this SDM risk assessment list, housing issues that probably most of our clients don't have that, but it's a big issue for DCFS sometimes, and for the parents who get involved with DCFS. They always want to know what's going on with the children. Are they very young children? Are they do they have some special needs? Do they have some learning disabilities, some medical issues? Because that all, again, increases the risk of something harmful happening to the child. And of course, this hypo fits in perfectly. Paragraph 11, I'm on page 89 of the materials, by the way. Incidents of domestic violence in the household in the past year. So if the social worker finds out that they're always going to ask, that's the point. During the interview, you should prepare the client that they're always going to ask about this. They're always going to ask about domestic violence. They're always going to ask about what your childhood was like. Were you abused as a child? Because to them, that's another indication that it's more likely that you are going to do something or something is going to happen to the child. Another thing is your mental health. Do you have a diagnosis? Have you ever been put on a 5150 hold? That they do this checklist about substance abuse, domestic violence, mental health. What was your childhood like? Because they're looking for other signs that would increase the risk. In a rough description, the interview can be divided into two parts: the allegations themselves and what they call the social history, which is their way of going through what I just outlined and trying to determine what else is going on here. What else should I be on the lookout for? And if social history is in a way a fishing expedition for them to see what else is there and to get to the allegations through another way. Because if you ask somebody point blank, they're just going to deny it. But if you go around it and you start asking questions about, well, what was your relationship like with your prior marriage? Or what was your relationship like in this marriage? Then they can get a lot more out of people sometimes that way. And Dmitry mentioned about how there's a jury instruction about what's acceptable discipline. And, the law says, if you don't leave a mark and if you do open hand spanking on the butt, you're fine. Well, I'm here to tell you that the first thing that they're going to do, the first thing that a juvenile dependency judge is going to do at the first hearing is they're going to issue a no corporal punishment order. So that tells you where their mind is at. The law may be what it is, but the expectation is don't hit your kids. I grew up in an old country like Dmitry. I got hit as a kid, but as an American parent, you better believe that I don't understand. I don't do any corporal punishment. My kids don't get the reference of I'm going to go get the belt. They'll think dad is joking, like, what, you need a belt? Your pants are falling? What's going on? Because I know from experience that if the social worker thinks that you didn't do something right, they may get the case going just to prove you're wrong. So I just don't even go there.
But Mark, before you move on, there's a couple of questions that I think are
Sure.
that would be helpful for you to address. One is, do they ever find unfounded anymore? Do you ever see reports that actually say unfounded?
Yeah, so I do. You're right to be suspicious and wondering whether that ever happens. Definitely in the type of cases that I end up dealing with, it's very rare. Their default seems to be that it goes into inconclusive because that's safer for them. But I have to be mindful of the fact that, I only deal with the really stressful cases. I'm sure they have lots of cases that are just frivolous and they just close them as unfounded.
And do you know how long that actually takes to get these assessments done? And that's definitely an issue in once the DB is filed. It seems like it takes longer than they're always they're still investigating.
Right. So there are different kinds of levels, right? So for example, Your Honor, if you were to refer a case to them, right? Or if a case involves sexual abuse or there's something really particular about this case that really screams out, it's going to get the highest priority. It's going to get a 5-day referral. That means that, drop everything else, go take care of this. This is the most important thing on your docket right now. I've looked through their manual and it says things like, from the time that the social worker gets it, they have 30 days. Okay. I get this question constantly from clients. How long is it going to take? They've done the interviews. What's now? What's going to happen now? And I always tell them the same thing. No news is good news. Let it fester out. Let the investigation go away on its own. Don't worry about the fact that they're not reporting back to you. Eventually, you're going to get that letter with that inconclusive or unfounded finding, and then you're going to be fine. But I've seen it go in as short as 3 to 4 weeks. I've seen it go to 1 or 2 months. They have their guidelines, they have their manual, but then if they feel the need to kind of watch the family over, then they'll do that. And when we were preparing for this presentation, we talked about safety plan versus family law court orders. I think it's important to point out that while they're investigating, family law is still in charge. So Commissioner Cohen can make orders and they will stand. The last family law orders will stand. What often happens is the social workers basically go to the parents and they say, okay, here's the deal. Here's the safety plan I want you to implement. And usually it involves the parent they don't like staying away for a while. And their selling pitch, if you will, is you do this or I take the kids away. Okay. So obviously people feel very threatened by that, and they never know whether they're bluffing, and people tend to comply with what they're saying just because they're afraid, because they don't want to find out if they really will do this, because oftentimes they do, just to prove their point.
So I'll see a declaration attached to a DV that says and it's probably not one that's represented. It might be represented by or assisted by some of the legal services partners that are on here, but it'll say the social worker told me, and this is their name and contact information, to file a DVRO to make sure that I'm protecting my children. And so that might be a way that I see that DV filed in our to initiate the case. And then oftentimes we try to make sure and find out, excuse me, in court, is that case and that investigation concluded? There were a couple other questions really on about that investigation and whether parents can record, should they record? Is there a body cam on the social worker like there are with police? And I didn't know if either of you wanted to comment on
Oh,
that.
yes. Yeah, you've hit on my pet peeve, because in 2015, I believe, the legislature actually considered a bill that would have not required, I take it back, would have allowed the parents to record the interviews. No other requirements from to the government, no requirement for funding, for example. Just allow the parent to record. What's wrong with that? It died in committee. It never saw the light of day. It wasn't covered in the press much. It just died. And to me, it makes every kind of sense in the world to allow parents to record, maybe even have the social worker record, because the technology keeps improving. It's not like it's that difficult anymore. We asked that of law enforcement. Why not do the same thing for DCFS? But no, California, and Dmitry can speak about this more forcefully. It's a two-way consent, right? Is that the right term? Both you have to have two-party consent. So if the social worker does not give consent for the interview to be recorded, then it's illegal. You can get into trouble for that. And that's why I have to tell people, look, you can't record the social workers because you won't be able to use it, and you can get into trouble for recording them. I think
body cams on, I mean, the social workers never record like they do.
Social workers never record.
And guys, let me tell you, while all what Mark is talking about, I just want to emphasize one thing. You were saying, Mark, that the investigations kind of linger, and the same thing on the criminal side. It's a separate investigation. I want everyone, I'm sure, to understand that while DCFS is doing its job, the police have their reports and they're submitting that to the district attorney's office. So we may not get news for a while from the DA about criminal charges, or there could be a criminal case that's filed while all this is going on. So even if DCFS closes its investigation, the district attorney's office is a completely independent actor, and the right hand and the left hand don't know what they're doing. In fact, the DCFS records, they're sealed. So even if there is an unfounded accusation, that doesn't mean the DA knows that. So that's where I come in to try to get that information over to the prosecutor. However, the records, I can't turn over from DCFS. I can just represent, here's my understanding, and perhaps Mark will write a supporting letter. But the fact is, the DA could file charges even if the DCFS finds these things completely unfounded. So I like to really be active in presenting relevant information to the detective in the case, who then turns the information over to the district attorney's office. So that's just an important fact to consider, that, hey, my client not only is dealing with the divorce issue and the dependency issue, but now there can be this other hammer of a criminal case being filed, even if everything's going well.
And I could see it not happening in dependency court, because maybe the social worker closed the case saying that this parent followed what Mark was saying and is not being able to be found for failure to protect, but the perpetrator is still going to be criminally charged. So it's not guaranteed that they're all going to be in all three of these at the same time. And that's where sometimes one, will move forward and one may not. But there are times when all three cases are being moving forward. And I think one of the things that we wanted to try to address today is it's challenging because the court doesn't know what's happening in the other courts, at least in family. And I didn't know if you wanted, I didn't mean to interrupt, Mark, but I just want to highlight a couple of the questions there. There was also a question particularly about emotional abuse.
Right.
Our hypothetical went into, tried to get a little bit more meaty there. But
sure.
maybe Dmitry can also address it when you're done, Mark, as to whether you see very many criminal cases on the emotional abuse only.
There's no emotional abuse criminal cases as far as I know. And I've done this 30 years. There has to be the risk of harm really relates to the physical risk of harm under the child abuse statute. So the child abuse statute does not require the child to actually be physically injured. It's either injury or the risk of injury. As an example, let's say a parent is driving with their child in a car, the parent is DUI, police stop the car, child is unharmed, there's been no accidents, that parent can still be charged with child abuse because the child was exposed to the risk of harm having a drunk parent behind the wheel. So, so in criminal court, you don't, I guess you can make the argument that emotional abuse, includes the risk of harm to the child, but as a matter of what actually goes to criminal court, emotional abuse cases are really rare without concomitant physical abuse or a risk of physical harm. So I hope that explains the criminal aspect of emotional abuse.
So to address emotional abuse, if you go to page 92 of the materials, I just put some highlights of the Welfare Institution Code section 300. Specifically, emotional abuse is addressed in subdivision C. It's C count in my world. They don't like them. They're harder to prove because it requires some kind of manifestation that the child is, talking about suicide, or they're harming themselves, or it's because it's hard to quantify when is child being emotionally abused. How do they manifest it? Because sometimes those kinds of emotional issues, they'll take some time to blossom. Wait till their teenage years, and then they'll really show you, what yelling at them costs you. But the default is Welfare Institution Code section 300 subdivision B. It's very broad because it covers things like neglect, abuse, failure to protect, substance abuse, domestic violence. As a matter of fact, oftentimes what will happen is they'll put it under subdivision B just to cover themselves. They'll plead it as a C, and then some similar fact pattern, they'll put it under B. If they're alleging sexual abuse, they'll put it under B just in case, because the burden is lower on them under B. So it's kind of like the default. So in the hypothetical that we discussed, where a mother is yelling at the kids, yeah, they may throw that in there in the petition, but that's not the one where they're going to really focus their efforts, because it's harder for them to prove. It's much easier to prove something else. But one of the questions asked about downplaying the DV, I don't know what I said to suggest that. No, social workers take domestic violence very seriously, and they always look for history of abuse. I think that what many people don't realize is that when they report domestic violence, when they say, yes, there's been domestic violence, he did this last week, and let me tell you what he did a year ago and what he did 3 months ago. As soon as they do that, it's failure to protect, because they didn't do something about the domestic violence a year ago or 3 months ago or a week ago. The social worker is going to put the parent into the petition just for that. I mentioned briefly earlier that once they make that substantiation of allegations finding, that it does not automatically mean opening up a court case. And I do want to say something briefly about that, because that's not something that the social workers will talk about to your clients, but it is there. If you look under Welfare Institution Code section 301, you'll see that the code allows the social workers to essentially enter into an agreement for 6 months with the parents. It's like having a court case without the court case. They tell the parents, okay, you have to do X, Y, and Z. We're allowed to check in on you for 6 months. And if everything goes smoothly, it's just going to go away and you're going to be fine. They don't often mention it to parents. it's there, it's available, and it's much preferable than having to hire me in addition to hiring Dmitry and family law attorney and somebody else. So I always bring that up, and I always try to push for that, because anything to avoid, 6 months of juvenile dependency court is fine by me. Randy Klein asked, therapist, mandatory reporter. Randy, a therapist is going to report anything that sounds like it could harm the child. Anything that I often find that, especially the less experienced ones, they're less sure of themselves, so they'll report the slightest thing, because from their point of view is, well, little Johnny said that hit me. Well, that's enough. Or mom and dad are fighting. For some are enough. I think the better therapist would dig a little deeper and understand that, well, they were just arguing. It's not a physical fight, so maybe there's no need to get social workers involved. I always hope for a therapist who would kind of slow things down a bit before just automatically reporting it. And it looks like what I was saying was addressed by a question. How often do parents get hit with a failure to protect if they report? All the time, because they don't realize how easy it is to trigger that. And then what happens is the social workers are doing, if they open up a case, then the next question is, do we keep the kids with one of the parents? Because if they feel like even if you fail to protect, but you're protective now, you're doing the right thing, then maybe they'll keep the kid with you while the case goes on. Again, a question says, I don't know if you were advising against admitting to being a victim. No. I'm not. You have to tell the truth, because if you're going to lie, here's what's going to happen. Little Johnny is going to turn you in. You tell the social worker everything is fine. We're just arguing, and then little Johnny, being a kid, is going to say, "I was really scared when mom hit dad," or vice versa. And then now you've lied to the social worker. That, forget the SDM risk assessment. You really triggered them. Now they think for sure they gotta open up a court case just because you lied to them. And so no, it's lying is the worst thing. What I tell clients is I can always explain the truth. I can never explain a lie. Okay, so even if you have some bad fact pattern, think it through. Think what you're going to say. There's still a chance to talk to social workers out of filing a court case, but if you lie to them, you've lost them.
So Dmitry, are you able to talk a little bit about some of the timing of things? Because I think that's one of the challenges is
Sure.
While DCFS is investigating, we may also have something going on in criminal court, and in family court, we have no idea how long it really takes for cases to go to trial, whether you have a CPO, what that might say is that if you get one, does that mean you have it forever, or could they ever be dissolved?
Sure. So, the criminal timing, there's, it's a little bit like a black hole. There's not, in this fact pattern, we do not have an arrest. So if there's no arrest, as the fact pattern indicates here, it's just LAPD is investigating, but there hasn't been an arrest. That means really the time period is the statute of limitations. So a child abuse situation such as here under a felony case, that's up to a 3-year statute. So that means they can file up to 3 years later from the date of the incident. And then the obviously if the child, if there's an abduction issue, there's they file abduction charges immediately if the child leaves the jurisdiction, and then usually the warrant stays in the system a long time until the child is brought back. Until the parent is arrested. And so really without an arrest, there's no specific time period. I have a case right now where there's a divorce, parents are pointing fingers at each other, criminal wrongdoing, the police is involved, but it's been a year and the divorce is still pending, DCFS is involved, and the police are not giving me the all clear that in fact, the client is not under, what you call the case has been rejected. The client is a partner in a major law firm. So obviously they want to get the criminal aspect behind them, but we can't. I keep calling the detective says the DA has everything. I call the DA says I have nothing. And so it's really a black hole sometimes with no police report, with no arrest. That being said, harkening back to what Mark was talking about, no news is good news, because not having a decision of somebody having to get prosecuted, the fact that somebody's record still remains clean, it's just a police report. As a matter of what that means, it doesn't mean you have a record per se. You haven't been booked, you haven't been arrested. That's a huge thing for somebody with a law license or a medical license or what have you. Down the road, in a situation where finally, if the case gets closed and there's a police report that's actually been filed, there's a new statute in California where actually conceal the records. It's basically a petition for the finding of factual innocence. And I have done that for about a half dozen clients. And so even if there is a police report pending, it's not, it's not something that has to stay in your record your whole life. That being said, if there was an arrest in this fact pattern, then we have kind of a faster timeline, because then when somebody, so let's just say the wife is arrested here for slapping the children, just leaving red marks. The officers on scene could decide, hey, this is what you call misdemeanor child abuse, combined with perhaps some of the verbal abusive language the son recorded, perhaps right on the cusp there of maybe even a felony case, especially if there's alcohol abuse issues. If police show up, mom is intoxicated, the kids have this recording, she's been abusive to us, cussing at them, and the kids have some redness when the officers show up because the husband has called, perhaps they arrest her for a felony. Then once she is bailed out, then we have a timeline. So usually it's about a month or 2 or 3 out. And then let's just say we have a court date after the arrest and after the bail, about a month. I use that month to try to get the criminal investigation closed. So even if somebody's arrested, that's not irremediable, because an arrest is based on probable cause. Okay. A court action is based on the district attorney believing they can prove the criminal charge beyond a reasonable doubt. So you have a different standard between an arrest and then an actual court case. So I would be working in that month to get all the information to the police about what a good parent mom is, perhaps the fact that she's now in treatment, seeking rehab, perhaps the fact there's never been a problem before, character witnesses, therapy. I get all that over to the DA and say, listen, there's no need for you to prosecute this case. So again, even if there is an arrest, that doesn't mean a case has to go formally to court. And again, we get a lot of cases closed even after the arrest without formal criminal charges in court. And that can also be what you call expunged, or those records can be sealed. So again, for somebody who's a lawyer, a doctor, somebody with a license issue, or somebody who's in the entertainment industry with a big name, it's a way to get the record sealed. So, the upshot is,
how long does it usually take, though, to go from that arrest to a DA or a city attorney reject, I guess?
It depends on how quickly the cop turns in his reports. And some officers just sit there with, hundreds of files, especially LAPD, but you go to smaller agencies, say Arcadia Police, San Marino Police. And so they have a limited number of detectives, limited number of cases. So that goes faster, but really up until the court date, Your Honor. So if you bail out, they give you, and so the way bail works is, you're paying bail company, they're putting in a bond. And then when the client bails out, they get a court slip, basically. You have a court in a month. So they really typically decide within that month period before the court date or whether or not to file charges. But I've seen cases where I go to court and the DA gives me a form saying, listen, we haven't made a decision yet. So keep checking, but it's what you call a proof.
What point would a CPO be issued? Would it be issued right at the beginning? Because we definitely see them and then they get dissolved.
So the police issue a 5-day protective order. It's a pink form to
emergency protective. So there's emergency protective orders. There's
I'm thinking of the EPO, correct? The emergency.
But the criminal protective orders sometimes come in the beginning of the cases while they're still in flux and haven't moved forward.
Sure. So just to give everyone that, so the emergency protective order is issued right away by the police, but then that has to be renewed after 5 days. So whoever is getting the order as the victim has to then go to court to get a further order. Otherwise it expires in 5 days. And oftentimes I see it getting expired because the spouses want to be back together. The criminal protective order, I believe, is only issued if there's an actual filed criminal case. So if I get the case closed, there's no one to issue the criminal order because the criminal court has no jurisdiction. There's no actual criminal case. And so even if I showed up at arraignment and get a proof, which you call a proof of appearance, hey, we were here, the DA has not made a decision on charges, there's no criminal protective order that's being issued. It's just because there's no court case.
We wanted to talk a little bit about when there is a CPO or criminal
Sure.
protective order, because
Sure.
there's a challenge on the form itself, and there's a box, this magical box that we always learn about in family court or in dependency court, that a CPO can then prevent anything that's happening in all of these
Right.
other courts. And then an attorney or somebody has to go back to their PD or whoever else to try to modify the box. And it's on the CR 160, which is the criminal protective order,
Right.
box 16. And if it's not checked, saying that they can have peaceful contact with the protected person as that exception for their visits with their children, it does prevent or preclude somebody from having visits, even if there's a dependency case or family court orders. So it's important for people to get those CPOs and to look at them. But I know in my department, it's a challenge. I rarely have parties or even attorneys come and hand me the CPO so I could see if there's something that needs to be modified.
So exactly that point, I have a case I just had in court this week where the criminal case has been pending for about 3.5 years without resolution because of the serious nature of the criminal charges and my firm's attempt to just keep the guy out of jail. So because I think the initial criminal protective order was like a year or two, I don't remember the exact time. We were just in court. The sentencing is pending, meaning the client took a plea deal. And basically, if he does well, the judge indicated he's not going to send him to jail. He's wearing what you call a scram bracelet, meaning no alcohol. And, he's been a great, he's done well for 3 years. So because the case is taking so long without a sentence, the court keeps having to renew the criminal protective order. And that box is what we were fighting for the last 3 years. There's a box on that criminal protective form which allows the client to have peaceful contact with his child. And the mom, so my client is the father, the mom was not doing well in family law court. So what she did was she came into criminal court to try to undo what family law has been dealing with for the last many years. It's a child custody dispute. And so we fought tooth and nail. In fact, I brought in the family law lawyer to testify to the judge to say, Your Honor, I understand in this case, it was like a child endangerment situation where the father, because of drinking, endangered the child. That's the general fact pattern. So the mother now went to criminal court while the criminal case was pending and said, hey, father should not see the kid. He's a potential abuser. He exposed the child to the risk of harm. And our position was, listen, the father's been doing well in treatment and rehab. Child has never actually been injured in this case. Yes, there was a risk of injury. And so the court, and I brought in the family law attorney to testify about the history of the family law case. And basically what you said, Your Honor, is that box is really a way, it's a war tool for the other party because the mom maybe ran out of funds for a family law lawyer and really was trying to go through the back door to have the criminal law case. Criminal law judge ordered the father not to have any contact with the child, despite the year's worth of decisions that the family law judge had made, allowing peaceful contact, despite the criminal case. So it is an important thing in criminal court for us as a criminal specialist to be able to allow the family law orders to be valid, but the criminal judge can just make a different decision. So that's a very good point, Your Honor. I'm glad.
And all of the restraining orders do have a priority of enforcement. And if you look at any of the forms, and some of those were included in your materials, the EPO, that emergency protective order, takes priority, then goes that CPO, And then down on the bottom is the equivalent of the juvenile DV, their juvenile protective order, and the civil DVROs as well. And so if there are competing orders, that's why it's really important that that criminal protective order be accurate, because that is the one that takes priority.
Right. It's important. Yes, I agree. And I'd say 99% of the judges, 99.9% criminal judges are very aware of that. Sometimes you have a new judicial officer, perhaps somebody that's never been in criminal or family or dependency. And it's takes a little bit of time to educate that officer about how things actually work. But most judges are keenly aware. Your Honor, I was going to ask you, what about, how do you deal with a DV restraining order? How do you decide on to grant or not to grant, and if there is the criminal case pending perhaps, and there's dependency issues, how do you deal with the restraining order aspect?
So there's a lot of things that interplay in the family laws world. I wanted to sort of parlay one more question before I guess I talk, because it's towards Mark, and some of the things that could impact what we could do in the civil DV world is depending if something happens in juvenile. So if this hypo was a little bit different and it started in the dependency world and then it closed in dependency, and then there is the famous custody order that comes from juvenile court, and then I find out that there was a dependency case, not necessarily whether there's a criminal case or not at the moment in this question, it does impact what I can order. If there's an open case, I cannot make any custody orders at all in a DVRO that's in front of me. And if there's a custody order, I try to find that information out. And I wanted Mark to talk a little bit about when you are ready to close out that case, what you're trying to do, because unfortunately it's not always done in the custody orders that I see. And then I can talk a little bit about how these things impact the cases in front of me.
Great. So let's say that they pull the trigger, they open up juvenile dependency court case. What happens next? Basically, parents get services. If the child is removed from both parents, then the services are called reunification services. If the child stays with one of the parents, then the other parent gets enhancement services, which are basically the same thing, but they're called something else. And also the difference is that judge has a lot more discretion whether or not to grant enhancement services. As a matter of fact, if the quote unquote offending parent, the parent that they really are mad about, is not doing well from the beginning, is not cooperative, there is a chance that once they sustain the allegations, then the department can recommend, you know what, we're not even going to give any enhancement services. The kid is fine staying with the parent who's taking care of the kid. The other parent is in trouble. We're just going to short circuit this. We got to the trial. We don't need to talk about the case plan. There's no services. We're just going to close it out with a juvenile custody order. So that can happen a lot faster than the typical, because the typical is 6 months. From the time of the trial, the next hearing date that the court for sure has to schedule is the review hearing. And at that point, the court has to decide whether to close the case or not, whether to offer more services, or whether to close it out with a juvenile custody order. The interplay between family law and juvenile dependency court that often happens is that the goals of the courts are different. Juvenile dependency court is focused on child safety. Once they're satisfied that the children are safe because the offending parent has seen the light of day and they're doing better, then you can get spectacular custody orders out of juvenile dependency court. I'm talking about you're walking into dependency court and you have a restraining order against you, whether from family law court or from dependency court. You're only having monetary visitation, and then you follow your attorney's advice, you do everything that you're supposed to, and then you get to walk out of dependency court with 50-50 parenting time, which would never happen in family law court in such short period, because I know Your Honor is going to jump in and say 30-44, it doesn't apply in dependency court. You don't need to worry about rebutting the 30-44 factors. If they don't see safety issues anymore, the default is to suggest joint legal, they almost always suggest joint legal. And then they go for joint physical. And then what I think Your Honor was alluding to earlier is that oftentimes these orders are very, how do I describe them?
Not detailed.
They're not detailed, they're not thorough.
Reasonable visits for everybody.
Right, because then it's almost, they don't realize, the people who are drafting them, they're not realizing that unless they do these orders just right, they are guaranteeing that these people are going to end up in family law court. Guaranteeing it, because how do you, if there's no schedule broken down, how do you do this? Mediation is doing wonderful work in the Dependency Court. They have a very good system set up. The mediators are great. I can't believe some of the cases that they end up settling. I tell the client for sure it's not going to settle. There's no way, and then somehow they manage to reach an agreement. And when they do that, they help draft the juvenile custody orders, JCO, and then of course they're a lot more user-friendly for family law court. And I think Your Honor mentioned a case of In Re CM that talks about how the 3044 issues don't apply in Dependency Court. So those exit orders, if you look under Welfare Institution Code Section 302 subdivision D, which is in the materials that were provided, you'll see that the exit orders, the juvenile custody orders rather from Dependency Court, they have the same power as Montenegro orders in family law court. They're basically final custody orders. In order to change a custody order out of Dependency Court, you have to show a significant change of circumstances and that it's in the best interest of the children to change those orders.
So I'm seeing a couple of questions, so I might try to answer some of these that are to me too. So thank you both for explaining some of the overplay. So when a DV case gets filed in family court, I'm a standalone restraining order department. So I handle all types of restraining orders, not just DV. I handle civil harassments, elder abuse, and the like. And they often all cross over with some of the families that you're representing, because the CHs may include an ex or somebody else that's interfering with custody visits. I may also have an elder abuse that is really a family member that's also trying to do some kick out order or something like that against some of your families. And then many of them have nothing to do whatsoever with the areas that are interested to all of you here today, but that is on my docket. Once I, as a standalone restraining order department, learn that there is a dissolution or parentage case, I will, under the local rules, relate it and transfer it to that home court. And that really is for purposes to make sure that all of the requests within that DVPA are being addressed by a judicial officer that's able to handle everything else that's within the home court case. There are some differences between a DV case that's in family and a DV case that's in dependency. There are times when I do learn that the case is going to be filed on, as we're talking about here today, but it can still remain. I can still have a DV case in family court. It's just that once a case is filed, as Mark was suggesting earlier, I don't have jurisdiction to make any of the custody orders, but one could still make a number of other orders. So for example, the family law restraining order can include the definition of coercive control to the victim, which is often the other parent. I don't believe that that's as clear as a finding in the dependency DV findings. I also can make orders regarding control of property, health insurance or other types of insurance, property restraint, debts, expenses, which is often why people want a civil family law order, and the support orders, child support and spousal support, assuming that they are a parent that still has the children in their custody, and attorney's fees. We also can order batter intervention, and then that famous transfer of wireless phone account, which is an issue today that is included in the DV forms. A family law DV can also be issued up to 5 years. I believe in dependency, it's only 3. And the other benefit for a family law DV is that renewal. A renewal right now can be 5 years, and the law is going to change. It used to be 5 years to permanent. Now it can be 5 years, and there's going to be some discretion for court to make additional orders in between. So I could perhaps make 12 years or whatever it is that you're requesting for. It doesn't only have to be starting in 2023, I believe, one or the other. So there's cases that say one person can have a CPO and a DV in civil and also dependency. Just because one is protected in one court, the court can't say, oh, you already have a criminal protective order against you, therefore I don't need to address that here today. With regards to the custody orders coming out, so I'm trying to understand sometimes, and it's a little bit of a stay in your lane. So as a judicial officer, my understanding is when a case is closed in juvenile court and there is this juvenile custody order, the clerk's office, excuse me, is supposed to generate a case number in family court, which is what we call an EX case number. It's not always happening. And so when I get a new case filing, I do my best to do a search under the minor's name and date of birth to see if there are any other open or active cases. So I can find out if there's a mutual DV in active right now in family court, if there's been an EX case, so that I'll know that there has been a dependency case, or if there is a home court case. I do that search because that's my day job, and I handle these restraining orders all day, every day. There are times when I'll see a DV that's filed and it'll say I'm concurrently filing a dissolution. Until that case is filed and assigned to a home court, I would still be that court. And so there would be a separate restraining order case number under a restraining order number, and then there would be a family law case number that's generated. And again, that would be back to when I said I would relate and transfer once I discover that. If I find that there's a dependency case, I can only see that there was a dependency case. They're confidential. So if I wanted to go and see what those custody orders are, if I can't find an EX case number, or I want to find that final minute order when the case was terminated to see, was that child released to both parents? Was the child released to just one parent? Were there any specific orders? I have requested access using the juvenile form 037. And in dependency court, you would see that I've filed that request. I specifically indicate that all I want is that final minute order. I was a dependency attorney way back when, so I know what it's like to review that whole file, but it's confidential. So as an officer of the court, I don't just open up every single child service worker report and just go looking to see what happened in that case. I only want that final minute order because I want to know what the orders are. Could I potentially be, did the case just close? Was the case released to the mother and now all of a sudden the other parent is trying to file a restraining order against them? Were there parentage findings? Were there orders that I need to make sure that under the DV original filing, I could make some protection orders, but when it comes time to the hearing, I want to know what's going on. And oftentimes, certainly self-represented litigants don't always come with all of the papers in hand. And so it's helpful for me to get that information. When I have one of those cases, I do disclose it. I let the parents know that I did ask for this information. The court's only looking at the final minute order. And I actually asked for their permission if they wanted me to look at anything else. It's hard to get sometimes, but the clerk's office has been fairly quick for at least the judicial officers to get that information. With regard to the final judgment, as Mark said, there are times when people leave dependency court. If they were still in dependency court and they weren't happy with the orders, they could file a 388 motion. It's exactly the same. They'll file an RFO. So the case will close, and then 2 weeks later, 2 months later, or 2 years later, they're going to file an RFO trying to modify those final orders. And that's something that could come before me if there was a restraining order. And then it could also come in the home court case if there's no restraining order and they just want to modify those orders. The items that I wanted to address, since I have many of you coming before me, and I have a dog that's crying in the background, so I'm sorry for that, are things that when you come to any family court, I want to remind you that all of the DV cases, we are judicial counsel for mandatory. So I appreciate when you have counsels on both sides. You came up with a great stipulation. You want to continue so you can meet and confer. You know that Dmitry is representing your client in criminal court. You want to find out what's happening in that case, and you're going to just put it over. And you have this stipulation. I still need the DV 115 and 116 forms to be filed. I also need you to agree that you're going to put it over beyond the statutory time period. So I'll need a waiver of time if that's what's going to happen. I also want to make sure that you could mediate some of those issues, because oftentimes at that emergency stage, there's an order for no visits. And people don't want to wait for Dmitry's investigation for months and have absolutely no visits. And so it would be my hope that you can meet and confer and try to discuss something. Is there a professional monitor? Do you at least know what days and times people are available? Do people want to get their property out of the house? Do you at least have an agreement for that? I'm sure there are some things that could be agreed upon. At least can you agree upon a date to continue the case? So I don't spend 10 minutes with a court reporter, because I'm lucky to have one, and I will still have one after the 14th. But I don't want to spend 10 minutes trying to figure out what everyone's calendar looks like, what vacation you're going on, and things like that. Happy that you're having time to go places, but those are really helpful things. And then any information that you had about a case that might be with Mark or a case that might be with Dmitry, anything that you can share with me is helpful information. So if you have that CPO or you have that report that says it's inconclusive, please let me know so I know where we can go with that case.
Your Honor, in our preparation, we discussed this question. How would you deal with a request for continuance? There's a restraining order before you. We could ask the question two different ways. If there's a criminal case open or if there isn't. But we do have to mention the case of in re marriage of Sachs that's in the materials on page 93, I believe, that talks about what happens when you get that request. And also we discussed in preparation invocation of Fifth Amendment. I think that's also an important consideration.
Definitely. So by statute, respondents get one statutory right for continuance. And so obviously that's granted. After that, though, it has to be good cause. And so balancing somebody who has a pending criminal case, that's very likely to be good cause. It also depends if there's a temporary restraining order, if it's an investigation, or whether there's actually a criminal case. So that helps me understand how long things would be going out for. If you're able to meet and confer and you come up with some agreement that we're going to just put this out for 6 months and see what happens with that criminal case, and we want the TRO to continue, or we want to amend the temporary restraining order, that's fine. I'm happy to grant that. I just can't grant it on a stipulation that's signed without the DV forms. So I would need an amended temporary restraining order, an amended 110 with any custody orders that you've agreed upon. If you can't agree upon those custody orders, but you're willing to stipulate to put it out, then I can address that. At some point, because I fully respect the Fifth Amendment, I would never push somebody to testify. Even when I've self-represented litigants, I tell them, it sounds like you have a criminal case pending or there's an investigation. I want to advise you of your Fifth Amendment right to remain silent here today. It doesn't necessarily mean that I will continue and find good cause to continue the case for months or perhaps years, because at some point the court must do a balancing test if the petitioner wants to proceed. You may argue, but they have a TRO, what's the difference? But at some point they have the right to go forward with their hearing. They may lose witnesses, they may lose their memory, they may not have the evidence. And it is abusive to somebody who's a victim to continue to come to court over and over again, waiting for their hearing, while the other party may be re-victimizing them by just coming to the court itself. So I think that tries to answer the question. You know, it depends on the facts that are before me. So there's no bright line rule other than I always grant one because it's by statute. But after that, I encourage attorneys to try to meet and confer. There are collateral consequences, I think, as Dmitry was talking about, sealing records that are different, whether it's a temporary restraining order or a permanent restraining order. Not saying that a victim of violence should try to ever meet and confer away their rights to be protected. However, if at the same time somebody's also wanting some other financial support orders, if there's a permanent restraining order, as to some of the clients that Dmitry was saying that he represents, they may lose their job. And so if you're seeking support orders and also a restraining order, and you want to keep the house, to keep your children in, a 3-year, oh, just let them submit to a 3-year permanent restraining order and then we'll be back, that might have some consequences. So I just encourage you to really look at the difference between what you might be encouraging a client to stick to. So I have seen, and I'm not saying you should or shouldn't do any of this, and then also all of these are, depending on the cases that are before me, I'm not giving you any guarantee as to how I would rule, but I have seen attorneys stipulate to like a 1-year temporary restraining order to continue and then see where things go. And that may allow somebody who's licensed to not lose their license, but still allow a victim or a petitioner to feel protected.
Absolutely. And that case that I mentioned on page 93 in the materials, in remarriage of sex, does say that basically invoking Fifth Amendment does not mean that you get to stop the court from discussing other things such as child support, such as property division, whatever it may be. The case goes into great detail about what is allowed. This is a discussion that Dmitry and I often end up having, because I can understand from Dmitry's point of view, he's telling the client, look, just don't talk to anyone. You have serious charges pending, but from the point of view of there's a restraining order pending in front of Commissioner Cohen, what do? Do I just give up and not do anything about it? Or if a social worker is demanding an interview, yes, you can invoke Fifth Amendment as part of investigation by social workers, but then they will kind of use that against you, because it's not a criminal case and they can use it against you. Your silence can be used against you, and they can say not cooperative, not responding to questions. So then it increases the chances that they will go ahead and open up that court case.
I know we're coming up on the noon hour. I don't know, Dmitry, if you wanted to say anything in closing.
Sure. As to Fifth Amendment issues, at my firm, we really don't want clients making statements that can later be used against them. Oftentimes, people start talking and they're going to say all sorts of things that are outside of your control that just may hurt them. So I typically speak for them in the sense of I present a written position with supporting evidence and documents to the officers and to the district attorneys to get the case closed. I understand, though, that they want to see their children, and I don't want to have their ability to be a parent harmed by the fact that they can't talk to dependency folks. So I usually let Mark take the lead on that. That being said, if it's a very serious case, if it's a murder case, attempted murder case, very serious child abuse, if there's a death involved, it just depends on how serious the consequences are. If it gets to that level of seriousness, then they're not going to talk, period. But most of my situations when, everyone's alive and doing well, I'm okay with Mark being present and making sure the client doesn't say anything to harm their ability to keep custody. So it really depends on the seriousness of the case. But in criminal, I never let my clients talk. I talk for them. I can write out their statement. Sometimes I'll just sign something rather than be subjected to an interview and an interrogation by a detective.
There was one question about a gun violence restraining order. Those do come before me too. They're really not used as much as they could be and should be, perhaps here in LA County. But I don't know if that was in response to saying that sometimes cases are continued, but every single restraining order has a gun restriction order, and that cannot be crossed out. There can never be an agreement for it. There might be some exception, but I have yet, in the 4 years I've been on the bench, had somebody successfully get their firearm returned to them as a matter of their occupation. So you can look at the statute as to how you could perhaps overcome it, but it is an automatic order. So I don't know if that answered that question.
And also the police always come in during a domestic violence arrest and seize all the guns, even if the guns have nothing to do with the case. Even if a gun wasn't used, the police will come in and take them all as part of the investigation.
Dmitry, I had one question for you, if
Sure.
you don't mind, because this is something that recently came up in a case that was new to me, is that if you have a couple that are still living together and one of them calls the police or both of them and report DV, that the police will not leave the house unless they take one. Is that accurate?
Take somebody away? No.
That they arrest someone?
The police say that to justify what they're doing. No, they come out on calls all the time where they don't make an arrest. It just depends on number of calls that have been made in the past. I've seen cases where somebody's finally arrested and there's like 5 or 10 prior calls for the police to come out. So that's not necessarily the case. It really sometimes, the old saying is beauty is in the eye of the beholder. Sometimes the police, just something that happened in that incident, maybe they see a little redness, maybe somebody's drunk and aggressive with them. Some circumstance they make the decision to make the arrest. Sometimes it's a rookie police officer. Sometimes they're just like Mark was talking about a DCFS officer who's upset. It could just be something intangible, but often I'd say most of the time police come out, they don't make an arrest.
I see a lot of police cards attached to all the petitions. I can tell you I've seen 10 of them, attached to one petition, and a lot of them just say referred to 111 Hill Street, file a restraining order. And that's what it says.
Because for them to make an arrest, they also, they can't be lazy police officers. They have to take the person, they have to go to the station, they have to book them. That's a process. So I suppose another factor is how busy they are that night.
If they do take and seize the weapons and you represent that party, I strongly encourage you to make sure that you're filing a DV-800 or having your client file a DV-800 if they have the weapons, if they were seized, or even if they had the weapons and they turned them in, because we are definitely moving forward with all of that under the codes these days to make sure that those forms and the guns are not in the hands of somebody who has a restraining order against them.
And some people are gun people. Taking their guns away is like taking their children away. The case becomes more over their guns rather than staying out of jail. They want their guns back. I mean, it is just, that's their thing, is guns.
This was great information. Thank you all for participating and spending your Saturday morning. We're greatly appreciative. And we're going to take our lunch break now, and I'll see everyone back at 1 p.m.
All right. Take care, everyone. Have a nice day.
Thank you,
Bye.
Dimitri and Mark. It was nice.
Bye-bye. Thank you, Anna.
Bye, Mark. See you.
Take care. Have a happy Saturday, everybody.